Please can I welcome everyone to this meeting of the Licensing Subcommittee taking place from the Wharton Suite, Winchester Guildhall. The time is 10 a.m. My name is Councillor Patrick Cunningham, one of the committee members for this particular Licensing Subcommittee. Please can I advise that all open parts of the meeting are being audio recorded and live streamed from the Council's website. In addition, a video recording of the meeting will be uploaded to the Council's YouTube channel after the meeting. Can I remind anyone joining virtually to turn off their cameras and mute their microphones until invited to speak. May I also remind members to speak clearly and remember to use your microphone. In addition, please speak directly into the microphone and do not turn away when speaking. This will ensure your comments are picked up for the audio and video recording, as well as improving audio and improving the audibility in the room. Finally, please can I ask everyone to ensure that mobile phones and other electronic devices are on silent or entirely switched off. Now, moving on to the agenda and procedure for this meeting. Item 1, to confirm a chairperson for the meeting. Members, may I ask for your confirmation of my chairmanship of this particular subcommittee? Is that agreed? Agreed. Thank you. Disclosure of interests. Do members or officers have any interest they wish to declare? Thank you. Now moving on to the agenda. Item 3, application for the review of premises license, Wickes Bar and Grill, Unit D, South Square, Knoll, Fareham, PO 175FL, report number LR 562. The hearings regulations require that the hearing should take the form of a discussion led by the subcommittee, and that cross-examination will not normally be allowed. We will be following the adopted procedure of these hearings, which is set out on the reverse of the agenda paper. Each party will be allowed equal maximum time to exercise their rights at the hearing. I will exercise my discretion to allow additional time if necessary, taking into account the requirement to allow all parties equal maximum time. Only those points contained in the written representations, the report, and the supplementary documents can be raised. No new evidence can be considered except with the agreement of all parties. I'd like to introduce my fellow councillors to the subcommittee. Councillors.
Councillor Westwood.
Councillor Brown naming.
Now I'd like to ask the officers and representatives around the table to introduce themselves, please.
Nathan Mountney, Solicitor.
Bryony Appletree, Licensing Manager.
Abby Toms, Environmental Protection Manager.
Bill Tidridge, Chartered Environmental Health Practitioner.
Chris Dyke, Restaurant Manager.
And George Madrick, licence holder.
Thank you all. The subcommittee has read all of the written comments on the application for review, which are included in this report. I understand that Bill Tittridge, the applicant, Environmental Health, Winchester City Council, George Madrick, Wickes Bar and Grill, and Christopher Dyke, Branch Manager, Wickes Bar and Grill, who wish to be addressing the subcommittee. The subcommittee will also have due regard to the national guidance and the Council's licensing policy. I call on Bryony Appletree, Licensing Manager.
Thank you, Chair. So this is an application to review the premises licence currently in effect at Wicks Bar and Grill in Knoll, and that licence is currently held by Parnell's Food Outlets Limited. The premises is currently licensed for late night refreshment and the sale by retail of alcohol, and that's for consumption both on and off the premises. And the premises is also permitted to provide live and recorded music between 8 and 11 every day, provided that's for an audience of less than 500 persons, in accordance with the deregulatory changes made under the Live Music Act 2012. The review application has been made by Philip Tidridge on behalf of Environmental Health. They are a responsible authority under the Licensing Act 2003, and the application relates to the prevention of public nuisance licensing objective. The full application can be seen at Appendix 1 to the report, and that's from page 13 in your pack. No representations have been received from any other responsible authorities, and one representation has been received from one other person, and that is in support of Mr. Tidridge's application. That's shown on page 27 of the subcommittee's options for determination of this application can be seen on page 8, and just a reminder that we have a legal advisor present to assist you. Several supplementary agendas have been published following the publication of the original report. So just a reminder to all parties to make sure that we refer to document numbers and page numbers when referencing any printed documents, just to avoid confusion. I welcome any questions you might have about the licence or the application.
Thank you, Ms. Aldrich. Councillor Westwood. I have no more questions at this time. I'd now like to call on the applicant for the review, Mr. Tidridge. Mr. Tidridge.
Chair, before the applicant commences, there is an issue in relation to some paperwork that's been received that needs to be clarified, and you need to make a decision on. So forgive me, Mr. Tidridge, for intervening. The issue is in relation to late representations received potentially from both parties. And what I want to do is to address, forgive me, both the applicant and also the licence holder in relation to the submissions that they've made in relation to essentially the position with regard to the regulations. In essence, there is a 28-day time frame following the application for review within which representations can be received both for and against the application. Submissions have been made by both sides stating that they're late representations, but I do need clarification on whether or not they are late and then whether or not they should then be considered by you moving forwards. The reason I intervene now, of course, is that reference may be made to those representations both by the applicant and the licence holder. So, Mr. Tidridge, you, in the report provided by you in support of the application, there is reference to two representations that were received whilst you were on leave. Can you just confirm that that is correct?
That is correct, yes.
Let me just, let's find actually not in the application, it's in the first supplementary agenda, I believe, which is your pages 5 and 6 of the first supplementary agenda 2, is that right? It is the one that looks like that. There we go, yes, I have it in front of me now. So supplementary agenda, the first one, page 4, if you will. There's a paragraph there that says there appears to have been some understandable confusion by local residents about the mechanism to make a representation. I received several emails that in my view had the intent to make a representation. Unfortunately, these were sent to my email address whilst I was on leave. My out of office was on, and by the time I returned, the deadline of 28 days to make a representation had expired. Can you confirm whether the emails received were received within the 28-day time frame, or whether or not it was outside of that? Can you recall?
I can't recall exactly, to be honest. I
Right.
believe one would have been and one wouldn't. But
Which
that's to
one,
the best of my knowledge.
Can you recall which one fell within and which one fell out, please? Are you able to ascertain? Is there a way of finding out?
I can,
Sorry
by
to put you on-
searching my emails, but yeah.
Take some time.
It would take some time, yes. It would take about 15 minutes.
Just in order to ensure this is an issue and a point that's been raised by the license holder, and in all fairness to him, it would probably be wise to ascertain what information you are to consider in making your deliberations and what information you are not to consider. Just in for fairness and parity in these proceedings, we want to ensure the right information. So it may be worthwhile, if everyone is in agreement, to go and ascertain which of the representations should be considered. So we will do that with your leave, sir. And obviously, the license holder's information has not been provided to you because we were of the understanding that they fell outside of the 20. Therefore, should. I would ask the license holder just to clarify that that is definitely the case, and they did outside of the 28-day time.
Thank you, Chair. Yes, I can confirm that the representations that I submitted did fall outside of the 28-day term. That's why they've been rejected by the legal advisor. But just to reiterate, which I spoke to the legal advisor before about the hearing, I provided him case law in regards to Albert Hall before the date. Irrespective, I know you may adjourn to confirm the time states of their late representations, which unfortunately have already been submitted and for some reason accepted. However, this case law actually covers the fact that a backdoor process can't be used for late submissions under any circumstances. There's case law in the High Court which states that the Westminster Council had an error on their computer system, and that made that the representations happened to come in late. And the judge in this case actually determines that late representations, even under those circumstances, cannot be made, and they actually threw the case out entirely because of that. Now, I'm not saying I want the case thrown out because I don't want to be back here again, like none of us do. So please, I'm not suggesting that, and don't take this case law literally. But what I am saying is that late representations have already been given to the subcommittee here in their licence impact, which completely and utterly is unreasonable and unfair. They've already been provided these for a week. My ones were rejected, and it's in complete breach of case law. So I would ask the legal advisor, hopefully, just to read through this in the adjournment and confirm that, as I say, because just to confirm, Westminster City Council did submit late representations using a similar method, and the High Court determined that that was illegal and illegitimate.
That's fine. Thank you.
Thank you.
So I will read the case law and clarify the point whilst those emails are sought, again with your leave, sir.
Yes, I think I shall adjourn the meeting for 15 minutes until we have got sight of those additional documents, please. Thank you. Thank you. The meeting is now reconvened. Mr. Mountney.
Thank you, Chair. We've had a moment to consider, first and foremost, the case law that was provided, and it appears to essentially discuss whether or not certain locations, addresses fell within a particular catchment, and essentially goes on then to talk about why late representations then would have been received. I've discussed the matter with the licence holder. He's quite content with that understanding. If I'm wrong, then he needs to object now. But he's more than happy to proceed on that basis. That being said, the clarification from the applicant is essentially, and again, I would ask the applicant to confirm that both the representations annexed to his supplementary agenda, both are out of time in any event. So I would ask you if you could consider the first supplementary agenda, please, gentlemen, that's been provided to you. Pages 5 and 6 to that supplementary agenda. Now it clearly talks at page 4. There appears to have been some understandable confusion about to local residents about the mechanism to make a representation. I received several emails that had the intent of making a representation. So it clearly is that to that effect. So I would ask you to consider pages 5 and 6 that are headed Resident 1 and Resident 2 to not consider those in making your deliberations. Chair, can you confirm that you understand that position?
I confirm we are not going to consider those representations.
Thank you very much. I believe that you addressed the applicants with a view to presenting. That's where we left the process on the last occasion. So.
Yes, that's right. The applicant for the review, yes, Mr. Titteridge, you're back on again.
Thank you, sir.
Thank you, Chair. Interesting start. On we go. Have all the information. Don't intend to read it all out to you, as you've give you a synopsis of our position, a few comments that may assist, and confirm that the environmental health were first involved again at this premises, being easing of lockdown and the commencement of this venue starting live music, which is, as we have heard, on the license per se, but it's a deregulated matter under the law. First received complaints in early December 2021, and following various discussions, we put sound recording equipment in. This is unattended sound recording. I'm going to call it an NNR, so that's horrible acronym, noise nuisance recorder. It's basically a sound meter in a box with audio capability under the control of the person who put it in. We put it into a local resident who had raised issues, and we recorded the noise on the 10th, 11th, 14th, or they did 10th, 11th, 14th, 15th, and 16th. I could tell exactly what sort of tribute act it was by listening to those recordings. Here, normally, if in somebody's bedroom, local resident, and this was a child's bedroom, in fact, you can hear what sort of music, that it was Michael Jackson on the 10th, 11th, Freddie Mercury or Queen, I think it was Freddie Mercury, on the 15th and 16th. That causes us some degree of concern. However, we then at this point raised it with the applicant, but of course Christmas got in the way, and understandably the applicant is the guy over the Christmas period. It's a period for them. We met with the applicant eventually in March and went through all our concerns, and we agreed some potential way forwards, including expressing our concerns about this premises for regular live music. Has to be remembered, this is a converted church or chapel. It's listed, has very poor acoustic qualities of the nature of that sort of premises. It has had a history, as I've put in my representation, of issues from previous license holders, 2011 to 2015 when it was Artie's Wine Bar, and 2017 to 2018, and when it was called Clifford's Brand, and we'd had issues of a similar nature relating to the two previous occupiers using this sort of building for a lot of for live music events. We did meet Mr. Madgwick, and we had a very lengthy chat at his premises, and it was agreed that we expressed our concern about suitability, but it was agreed to give him a chance. He could have a go at seeing what he could do, and we got a list from him of events that were coming up, and with his knowledge, he said we would be monitoring some of those events. So we weren't doing anything sneaky beaky, and it was very much he was aware that we'd be doing it. He also gave a commitment at that point to finish the events at around 21:30 to try and lessen the impact. Fortunately, from the monitoring we did, that did not occur. It did not. We therefore went ahead and we monitored those events on the 18th of March, 1st of April, 9th of April, 15th of April, and 23rd of April. Those were all attended site visits out of hours by officers. So it's quite a commitment for a service who doesn't have an out of hours service. It's at the goodwill of the officers to attend. Make sure we covered representatively the impact. We used officers who all have these things. They're called ears. We all got them. That's the best way of establishing the level of impact, because what we're talking about here is public nuisance. How does it impact upon people in their properties? And the best way of doing that, although we can take sound recorders and numbers and things like that, and we'll come back to that, is actually for officers to go. Present here is Abigail Toms, who attended one of those sessions, and also in the audience is Harry Vaness. I've included, totally unaltered, their site notes that I asked them to produce for each and every visit they made, and you have those in the appendix. They're totally as produced. No officers discussed their visits. It's important that we all have a view. So what happens is everybody goes ahead, does their visit. At the end of those visits, we get together and we say, well, where are you? Unanimously, all the officers that attended, that includes the head of the Environmental Health Service, David Ingram, or now called Public Protection, Abigail Toms, who's my immediate line manager in charge of the team, attended. Myself and Harry Vaness, who's actually in the audience there. So possibly if you did have questions about their file notes, they are actually here. But I'm here to present the case. So every single one of those officers were of the view it was a public nuisance. That amount of noise occurring, it would disrupt people within their bedrooms, within their... We did also, going to the half of what's left of this additional information, take some sound level recording. I don't want to get too hung up on the numbers, because the numbers really just model the impact, and if you're there, you've witnessed it. So actually this is about how it sounds. But for purposes of just giving you some additional information, I have submitted in the additional submittal one which starts with the graphs of the noise level, and the premises holder has queried that from a technical point of view, and hopefully we've provided the information he requires to be happy with those numbers. He hasn't confirmed that, so you may wish to check that with him, but I'm holding at the moment.
I'm happy to confirm the responsible authorities gave me the correct information in regards to the devices and the questions I asked in regards to specific technications.
Thank you, Mr. Madgwick.
Thank you. All I'd like to bring to your attention is actually, at the moment, because you've seen it, is the second graph, which is the one that looks like this, which is the red one. The reason I'm showing you that is if you want to know what sort of impact it is, sort of visually in terms of decibels, without getting terribly excited about NDB, above background and all of that. I think very visually, you can see here, when the music stops, how much the noise goes down by. So this is the noise with music occurring, and then you can see there's a drop there as the artist pauses between two tracks. So you can see there's quite a substantive impact. Visually, that's quite a good way of showing that. So you can see there is quite a substantive impact. So we've done it two ways. We've done it using our ears, and we've done it with a noise meter. But I don't want to get too hung up on the numbers, because actually the most important thing actually is to go and every single one of those officers thought it was a problem. We discussed this with Mr. Madgwick on the 19th of May, by this time by a Teams meeting, as he was just about to go holiday, and expressed our concerns and was upfront about that something needs to be done about this, and that the correct way was review, so we could formalise an agreement. At that point, it's my understanding, and according to our records, that he was potentially amicable to a solution that was once a month, but did have concerns about that being over the Christmas period, with more use at Christmas. And I can understand that reason. But I have to be upfront, I have to be clear, I have to be transparent, and it's not a thing really to have gentlemen's agreements about. Thus, I advised we take into review where we could have this debate in a correct forum, and that outcome could be agreed formally. So, because we couldn't agree over the Christmas periods, and that's why we continued with putting the application in for. I do know that the licence holder has now suggested hours, which seems to be far in excess of what we were discussing at that point. So I'm a little unclear, so you may wish to clarify whether my recollection of where we got to was incorrect or not in accordance with his recollection. But he's now suggesting once per week. That's probably what was happening anyway, so it's no alteration. Bear in mind, it's a restaurant. It's not a live music venue. But we do acknowledge restaurants do like to have special events, occasion to bring people in. So, although some local residents, as they would say, want no music, we're not asking for that. We're asking to bring it back to where we think is an appropriate level for a restaurant which has special events to bring people to occasions. And we were looking at once per month, with a steer that you may wish to have some discussion over Christmas period. That's not what local residents want, and it's clearly not what the applicant wants, so what the licence holder wants. We have to try and seek some sort of agreement. I would say once per week, plus a couple other things that the licence holder was looking for, New Year's Eve, Christmas Eve, Valentine's Day. That's 57 live music events offered a condition to that would still allow. That's, in my view, not a restaurant. So we are here having this discussion. What's appropriate? I respect your view may be different to my view. I would say very strongly what currently the licence holder has suggested, not a level that we think would solve some issue. That's a sort of quick walk through. A couple of other comments. The elephant in the room is there's nobody else here, local residents. Obviously, you have one representation now. I think that's not unusual. It's unfortunate, but this hearing was going to be in the afternoon of today, is now in the morning, and people have to work. So it doesn't surprise me. And let's be honest, there's a little bit of a emotive thing about this. It's a local facility, and people, if they feel they cannot be involved and leave environmental health to deal with this, they don't want to worry about getting any sort of flack for being seen to causing the closure, as has been suggested, of this restaurant, if this hearing comes to a conclusion which the licence holder, in his view, cannot live with. So it's not terrible, and I don't think you should read too much into the fact these people aren't here. It's pretty common. They all complain at me and then expect me to go and do my job and hide behind me because that way they don't have any concern about being seen in a public forum in an area which could be, for them, problematic because they have to live with other people and other races. In terms of other things I've seen the applicant has fairly late on, which I hadn't seen till this morning, because I was on leave on Friday, suggested a noise management policy. I welcome an additional condition relating to a noise management policy. Some of our premises licenses have such a thing. But let me make it very clear. This isn't about management. I've never suggested the license holder runs a completely unruly premises. Not about that. I'm not suggesting he's an irresponsible individual who needs to be hauled over the coals. It's about playing music in a venue that's really not suitable for that sort of regular occurrence of music. It is just acoustically poor, very poor. There's been, as I've said in my representation, examples of 2 other license holders having the same issue previously. So, yes, I welcome a noise management plan. It's a responsible thing, thank you. But it's not going to solve the problem because it's not about the music. It's about managing the people, generally speaking. The other thing I've seen is that the applicant has suggested he turns the music down when asked. There was one submittal from December of a correspondence when they turned it down. I can tell you that's not the feedback I'm getting. What the truth of that matter is, I don't know, but I wouldn't personally read too much into one submittal on one occasion to suggest the music is always turned down when certainly not what I'm hearing. I also note the applicant has provided very late, so we haven't had a chance to go to it, some technical specification from an acoustic person. We did provide full information on acoustics. This doesn't, it's just a one-page thing. I can't judge on that. It's not technical enough for me to say, oh, that's going to do the trick to put sound insulation in. A couple of things. One, it's a listed building, so could it be done? 2, we're both acoustically qualified. We're not convinced it can. 3, there is no technical support to show the sort of acoustic insulation calculations we expect to see. It's just got a statement. So it's welcome, but don't think it provides us with any confidence at this stage. And we have to bear in mind, we all do, the balance between the desires of the license holder and the issues of the local residents. And they've been having issues now since December. That's 8 months. And we can't keep kicking the can down the road. We have to draw a line. My point here would be, if you are minded to follow our suggestion, or close to, and subsequently the license holder sees that they can do it, and it works, we would happily go, enough, you've done it now. But that's going to take some time to do. There's nothing then stopping, subsequent to that, the license holder coming in and asking for a variation. And if we thought the issue had then, at that point, been solved, happy days. We would not object to that variation. But that's the proper way of doing things, not keep delaying it whilst we have another go at getting this problem sorted out. It's been 8 months. The proper way is to put controls in, so that's what you can have at the moment. If you then put all these measures in, including this suggested insulation, which I can't really comment on in detail at this stage, then there is always that avenue. It's not it's a living document, as we know. So there's nothing to say it couldn't. And if it wasn't causing a problem, we're very happy because locals are then happy and the license holder is happy. So that would be my view on those points. And I think really that really is my submittal and a quick few comments on the additional information. Now, I do apologise. There was a little bit of to-ing and fro-ing, which I note has caused a little bit of disjointedness. I did, as I say, said to the licence holder, I think we need to stop exchanging correspondence at this point last week, so we can have the rest of this debate in committee. Obviously, we try and be helpful as we can, so we did try and respond to the licence holder with any questions. We didn't actually submit any additional stuff to the licence. So we're just trying to be helpful, but there was a point where I think we have enough information and we need to debate that in this committee. So that's really my walkthrough and my position. I'm happy to answer questions. If you do have questions of clarity regarding some of the monitoring, as I say, 2 of the other officers are available here. So if it's about those, I can obviously ask them, or you can ask them direct if you wish, or ask me, and then I will direct it to them. Thank you.
Thank you, Mr. Titteridge. Where is there any question? Mr. Titteridge, I have one. During the time that the measurements were being taken, sound measurements, can you tell me whether any of the upper level windows were air conditioning within the premises itself?
As in, when we were doing the monitoring, it was taken, all the monitoring as is stated was taken bedroom and or lounge of residents' properties, and their windows were partly open, slightly open for what we call ventilation purposes. There is no aircon I'm aware of on the buildings that we're monitoring from, the premises that we're monitoring. In terms of the premises itself, didn't appear windows or similar were open most of the time. What you do notice is the noise level goes up a little when people exit the premises through the door, because obviously the door presents. That's particularly to the front of the premises. So we were monitoring, there's basically two buildings that run along the sides back, the front area, the courtyard area in front of it. And we have monitored those monitoring points. People were one to one side, one to the other side, and one to the front. Particularly to the front, you do notice when, as you would expect, because the door faces that way, when the door opens on that premises. But as I've said, I don't think, and I'm not criticising the license in terms of the management of the premises, it's a function of the acoustics of the premises. But
yes, please, thank you.
I'd just like to add, from my experience, when I was doing monitoring, it was from a resident's property in Brant House, which is at the front of the premises. And I did it with both the windows open and the windows closed to see the difference. And with I did it at the lounge. It's a flat, a one-bedroom flat, and the living room faces the front of the square opposite Wicks. And then the bedroom's on the same orientation, just set back slightly. So I did it in both the living room and the bedroom. And with the window open, you could hear, with the windows closed and the patio door closed, you could hear all of the music very loudly. And then when you open the windows, you could hear all of the words as well. So that was the difference between the two when I was.
Thank you very much. I'd now like to call upon the license holder, Mr. Madrick. Thank you.
Thank you, Chair. First of all, with the Chair's permission, of course, would it be okay if I just asked a few questions of the responsible authorities just for clarity? There won't be anything untoward. I just want to clarify some points so that you understand fully the situation.
Chair, you have leave to go on the proceedings as you.
I'll permit this to start off, and if you go out of order, I'll have to.
Of course,
okay.
By all means, of course.
Thank you.
No worries. I just want to ask, first of all, if you could please tell me precisely what's written in the Licence Policy Part 4, Section C, Paragraph C1.
no.
No. And could you also provide me with, and the committee, with the details of Paragraph 1.9 and 2.17 of the Section 182 statutory guidance, please?
Yeah, I think this is out of order. This is quoting long guidance, which I do not keep to hand. If I need to reference guidance, I look at the guidance. To expect me to suddenly be able to quote large amounts of pieces of legislation, it's derisive and is aimed at trying to suggest I don't know what I'm talking about.
I'll let you know the relevance now.
I'd like to know the relevance and what your objective in this case is.
The relevance is that in the report, and I'll be going through the report on a few occasions today, sorry, there's a bit of feedback from that, on a few occasions today. It's standard practice for when a report comes forward to a committee, when they're referencing points, they're referencing Licensing Policy Part 4, Section C, they're referencing the Section 182 guidance, but they've not added the sections that they're bringing us forward for review today. It's standard practice in a report for them to submit the guidance that they're referring to, or add it as an appendices for us to consider as a licence holder and you to consider as a licensing subcommittee. If they're not aware today, this very second, of what they're actually referring to on the laws or the legislation or statutory guidance that's been broken, how are we expected to understand or know what it is? And I just feel it's slightly unfair. And obviously you as a committee have got to consider this, but you've got no reference of what to consider. They've put in points and there's no
Thank you. I'd like to call on Abigail Toms, please. Would you like to add something,
Yeah,
please?
thank you. We don't have a copy of the licensing policy to hand with us now this minute, or the Licensing Act, but obviously the very purpose of that is to prevent public nuisance. And the whole reason for our application is to prevent public nuisance, which relates to both the licensing policy and the Licensing Act.
Also,
Mr.
Chair,
Martinet.
these are publicly available documents, so both the policy can be found on the website for the council, and also the Section 182 guidance is readily available on the internet. And I might wish to direct the question towards the applicant, but I imagine he would have access to these documents when formulating his report, and he would know what he was talking about when referring to those and read through those before submitting his report. And again, the licence holder himself, again, I'll reiterate, they are publicly available documents so that he can go to either the internet, the website, and find that information himself if need be.
Yeah, I'd just like to confirm I'm aware of what the license, what it says, but to expect me to verbatim quote things off the top of my head is unreasonable. But certainly I'm aware of licensing objectives, I'm aware of what public nuisance is, and I'm aware of the procedure. But to ask me to be able to quote that, why would I? It's publicly available for reference when I need to.
Okay, I'm going to stop your cross-examination at this point in time. I'm going to ask you to proceed with your own case.
Of course, just so you know, I have got the licensing policy here in front of me under Section 182. In relation to the public nuisance, which Abigail Toms referenced to, the 2.17 states, licensing authorities should avoid inappropriate or disproportionate measures that could deter events that are valuable to the community, such as live music. Now, in relation to my statement, obviously the applicant there obviously suggested the process and how everything come about, but I think it's important to give you a bit of background because I'm not sure if you're familiar with Knoll Village. But the venue is essentially the hub of the village. It's the only bar, pub, coffee shop, restaurant, whatever you want to call it, in the village. There is no other option. So it is used as a hub for the community. There's no passing trade, there's no public traffic, there's nothing. We have the locals. And that is it. Just to answer or just clarify a few of the points that was raised by the applicant, I understand that obviously what I've asked on the conditions are up to 57 events a year, and that is fair to determine that on face value, that essentially that is what could be required, but that is the maximum. I will stress that in January this year we held one event, in February this year we held 2 events, this month we've held 1 event, and next month we have no event scheduled whatsoever. So although the conditions allow, or the conditions that I've asked for allow flexibility, what I must stress is if you look at the current and the past history of our venue, they're not weekly. It just gives us the ability during peak times or peak seasons to be able to maximise our revenue potential, because at the moment, as you can appreciate, it's not the easiest of time post-COVID to do this. I actually really do appreciate the applicant coming forward and saying that I'm a responsible licence holder, and honestly I do appreciate that, and that the venue is not necessarily fit for purpose, and that's what hopefully I can answer today, along with going into this report a bit further. I did ask, as I say, 5 days ago for some information in respect or clarity from the applicant in regards to the total number of complaints that we've received. Now, it's normal in a report, especially when we're talking about public nuisance, to supply the committee and myself with a list outlining all of the complaints that have been received. To my knowledge, the report states that there's simply 6 complaints in December and nothing since then. And albeit they might try and bring new evidence today, that's obviously not allowed. But I did ask them 5 days ago if there was any additional noise complaints whatsoever that we could be referenced to, including the dates, times, and the references, because every single time somebody calls, they build a case and they can reference that. And I just find it crazy that in this report, there's actually no reference to any complaints whatsoever with details for the committee or me to consider. So, you know, when we're trying to promote the licensing objective as a public nuisance, I could quite simply argue that since December, their initial contact to me, there has not been any further complaints that we have got proof of today, and that's what we're going by, what we've been provided today on the report. So I was responsive to their complaint in December, and we ratified that. That's my first point. In respect of how the complaint first raised, and I think this is really important for committee to understand as well, the complaint was first raised during a temporary event notice, I believe, which we submitted in December. And it did go on slightly late. It went on till midnight. We applied till 2 a.m., but it didn't. It stopped just after midnight. And one of the residents was not happy, which was fair enough. But the really disappointing thing is that they went round to all the residents with a letter and posted a letter through the door to ask people and encourage people to complain. And then following on from that, they then knocked doors of residents, encouraging them to complain, which was really manipulating the situation and very disappointing. And that's how the complaint started triggering. That's how it all began, and then obviously you submitted noise record or sound recordings to record the 5 events. But another thing I find strange with this report today is that to my knowledge, we've got no recordings. They've recorded audio recordings, and apparently you can hear every word. But we hear the recordings, because I would debate whether you can hear it. It's all subjective to opinion. It'd be very useful today for us, for the committee, to understand if we actually have proof of any form of recordings today to listen to consider, because I haven't heard anything, and I don't think it's too loud. But there's that as well. Now, one of the questions I was going to ask, which obviously I won't ask now, is I just want to clarify the process, and the applicant was really useful in explaining how they contacted me in December originally. They expressed the concerns, and we immediately tried to resolve these issues. And then it took till March for them to come and visit us. In March, we went through all the dates of all the bits and pieces, and I have actually attached a contract in my appendices. I think it's item number 7, it might be, it's number 7 and 8 of a contract of Michael Jackson. The only reason I've put that in the pack for the committee is just because it shows there that the artist is using an external system, because we have our own internal system as well, but the Act sometimes likes to use an external system. And the issue with an external system is we have no ability necessarily to control the sound. And we discussed this with the officers in March, and we noticed in March, that the dates that they had mentioned to me that they had complaints for, the artists happened to be using the external systems. It was agreed, as the applicant states, it was agreed that we would work together and try and find a way of doing it, cooperate together. And they were going to go away, and as they state, they were going to record five occasions. And you're right, they did let me know that they were going to do that, and that they were going to come back then with the details, and we were going to see if we could work on a way to promote the licensing objectives. Although I didn't feel that we were in breach of them, we were going to work together on that. And that's when they stopped the cooperation. They refused to allow me to continue any form of. I mean, the thing is, they knew that the external systems might be a problem. And what I'm saying is they didn't advise that if they record 5 times and then that'll be it. It's going to a review. The idea was that they were going to record it, come back to me, talk about the results, and see a way that we could cooperate and move forwards. That didn't happen, and they were full well knowing that we were using the external system still, because I was fully under the impression that we were running this business as usual. They were going to come back with the results. We would analyse the results, which is what they provided by the decibels, and we would work together to promote that objective, whether that's moving the stage, moving the sound applicant, only using our internal system only. That was the plan, and that was what we were working on. And I would like to reference the statutory guidance here for the committee, which is 11.10, which states, where authorised persons and responsible authorities have concerns about problems identified at a premises, it is good practice for them to give a licence holder early warning of their concerns and need for improvement, which they did. and where possible, they should advise the licence or certificate holder of steps they need to take to address those concerns. A failure by the licence holder to respond to such warning is expected to lead to a decision to apply for review. Cooperation, however, at a local level in promoting the licensing objectives should be encouraged, and reviews should not be used to undermine this cooperation. My full argument as well today is the fact that we had an agreement to cooperate. We were going through the process with them, and then in May they boom, stopped. They stopped cooperation completely. Not me. I was willing to cooperate. I was willing to look at sound options and things like that. And just as a side note, you know, in respect of talking about sound, to give you a bit of background, my first 10 years before this, I was always a license holder, but my job was actually sound. So I travelled the world doing sound production for like arenas and large artists. And one of my jobs for a holiday park company was to consult on their sound because there was sound bleeding from a venue, and I was brought in to consult on that. So I do have a certain level of expertise in sound. Now, I wasn't going to bring this part up, but as the applicant has brought up the decibels, I do think it's incredibly important that the committee, I'm not sure how aware you are of sound levels or how decibels work, but I thought it was really relevant. So TLC Direct, which is one of the UK's leading sound manufacturers, which I'll quote here, has given an outline of decibels. So firstly, what we got to realise is that if something's 60 decibels, for example, if the sound is reduced by half, that wouldn't necessarily bring it down to 30 decibels. It works out that for every 10 decibels you drop, it's about half the sound. Now, to give you an idea, a leaf blower that's used is 95 to 115 decibels. A washing machine, for example, is 75 decibels. And speech, the way we talk to each other in a room, is 60 decibels. So it is, and they state on the website, which is their guidance, it is reasonable to suggest that 55 to 65 decibels or above would be defined as unreasonable in reference to the licensing objectives. So they're talking about 55 to 65. Also, as a note on that, the hse.gov.uk website, which is the government website, the forum there states the following. The General Code of Practice for Live Music of 8 states that anything less than 65 decibels would be reasonable to define as non-invasive. Now, I know what the applicant will say. They'll say, well, it's subjective, which it is, because unfortunately, as a committee and as a license holder, we've got no law. It's just guidance. But there's some guidance from you. But you've got the report there. What decibels are we talking about today? Right, the lowest end that they've recorded on their decibel meter is 34 decibels, and the highest average they've provided to the committee today is 46 decibels. So to put this into perspective, we're talking about a whisper. A whisper is defined as between 30 and 40 decibels. So we're literally talking about the invasive of a whisper. That's factual. One other point, because this report is really disappointing for me, and the chair asked the applicants about the conditions of how the sound recordings were recorded. Now, in relation to the methods of recording, I'm going to argue, and they're not going to like this, I'm going to argue that a number of these sound recordings, well, pretty much all of them are illegitimate. Now, there is one legitimate sound recording there, and I'll explain the reason why, and that's from Abigail Toms. This is the illegitimate one. And the reason I say that, and I'll explain the reason why I'm saying this, is because it's stated in the report that the monitored noise levels from inside the lounge of the customer's property with both the lounge window open and closed. Now, in Harry Vanessa's report, it states on 3 occasions that the window was opened, but not that the recording took place when the windows closed. National guidance states, and I'll quote this as well just for fact, because I'm trying to state a fact here. National guidance states, when using recording equipment to present as proof in reference to a licensing review or a noise abatement notice, it states the following. Officers should commence recordings without manipulating the surroundings of the location that they are using to measure noise from. It is good practice to record audio both with the window open and with the window closed, and clearly identify in the officer's report which recording relates to which method. In none of these reports, other than Abigail Toms, who has done it completely correctly and by the book, none of these other recordings are, in my opinion, legitimate, because they haven't followed the guidance. It's unfair for them to. I mean, Harry Vanessa's. Let's go to Harry Vanessa's very quickly, which is page 20. What's Harry's? Yeah, 22. In the first recording, it says customer opened French doors in the living room facing towards the venue slightly to simulate what music would sound like in warmer months. That is clear manipulation of the surroundings. Clear. The customers opened the door. It wasn't opened when they entered the building. On the Saturday 23rd, 2022, with Harry did a report. Customer slightly opened the window in the bedroom. Again, at the bottom of that report, again, customer slightly opened the window facing towards the venue. So they've manipulated the surroundings to benefit a negative response. Now, I don't mind them doing that as long as it's fair and reasonable. And if they're going to manipulate the surroundings to have the windows open, then surely they should also record with the windows closed, which nobody but Abigail Toms did. Now, this report is honestly, so they're missing out proof of complaints. They're not done the full report correctly. There's so many things going on with this. It's really, really bad.
Chair, could I just intervene 1 moment? How are we doing for time, Chair? Parity of time.
You're correct.
I can finish within a few minutes.
You are going to have to finish quite quickly, I'm afraid, Mr.
Of course. So, obviously, it's been agreed today that the average decibels was. It's going to take me about 2 minutes because I've got a really good point to finish on, if that's okay. I've got 2 points which are relevant.
I'm going to give you 1 minute.
1 minute. First of all, the noise decibel average on the reports, if we are taking them into account, was 40 decibels. And we're proposing that in the attachment I've sent you that we're going to change all of the bin location. We're going to remove bass bins. We're going to remove 3 of the speakers. We're going to change the locations. We're going to put soundproofing up. Now, I'll skip this point quickly because the biggest point, and this is huge, where is the noise abatement order? This is the biggest point I want the committee to reference to. If a premises breaks the legislation in respects of nuisance, it is mandatory. It's not optional. It is mandatory for licensing authorities or the environmental health in this instance to issue me with a noise abatement order. That is a legal requirement to do. They have not done this. Now, my argument is why? Why haven't they done this? Because if I had broken the law, if the noise was too loud, they could simply issue me with a noise abatement order. This is very simple. It goes to court. I have a right to appeal. I could fail the appeal and I would be found guilty. And then this committee meeting today is very easy. I, on Friday, tried to look for examples of noise abatement orders within motions, and there isn't, to my knowledge, there isn't a single example of anybody.
Time up. Thank you. Thank you, Mr. Medwick. Mr. Titteridge, would you like to address any points that have been raised by Mr. Medwick? Thank you.
Firstly, Chair, I'd like to just say Statutory Noise Nuisance Environmental Protection Act 1990 is a parallel legislation and therefore not really a material consideration for you today. If he has an issue with that, he should raise that through the appropriate channels. There is a very long technical answer to that one, but I don't think it's relevant. We're not considering statutory nuisance here, we're considering public nuisance through the licensing regime. Number 2, just a technical point of view, we are both acoustically qualified. For clarity, actually 3 dB, not 10 dB is the amount for doubling or halving noise. The 65 dB, don't forget there is internal standards and external standards, and you mustn't confuse external standards with internal standards. The noise is also, as I've said, related to bass as well as the absolute noise level. This is why I made it very clear. Though we took noise readings, we use these because, as you know, certain noises are more irritating than other noises. So it's a subjective as well as an objective test. And when you've got the bass with some degree of attenuation, it's the bass, we've all heard it, that comes through and is even more irritating. So I don't think whispering is 35, 40 dB. I think that's not correct. The answer as to why we didn't play the audio was to be fair to the license holder. This is such a big room, I can't get 45 dB to you, sir, whilst it's 45 dB to you, sir. So I would be accused of whacking it up higher than should be in order to get it to a level for you, or the other way around. I did trial that because actually I'd like to have done that. I actually came to this room and trialed it with these speakers. It didn't work, and I felt I would be accused of playing the music too loud and making it look worse by not having it at the appropriate volume. So I reluctantly then submitted those numbers as a second best. But that was not because I want to hide those. It's It's just sort of trying to be fair, to not have something that would be said, that's not what it sounded like in reality. But yes, we do have those recordings. That, I think, was all the things I wanted to say in response to some of the licence holders. But I think, yeah, that's probably all my notes. I don't know if Abby's got anything to add.
Ms. Toms, thank you.
Thank you very much for the compliment on my file note. However, the thing I would say is none of the officers were manipulating this around. Noise guidance talks about having the window open slightly for ventilation. And in fact, when I did the monitoring, even with the door closed, you can still hear quite loudly, such that I would have heard it above the vision, have been able to concentrate if I was reading, able to go to sleep. And that's the impact that we should be focusing on in this committee. That's what we're talking about in terms of these residents have been affected for quite some period of time. What I was going to say in terms of, yes, you know, assessing nuisance, it does require a subjective assessment in this case, and I think we've got a bit hung up on decibels here when we should be considering the impact on the local.
Thank you, Ms. Toms. Sarah Westwood, do you have any questions?
I have a couple of questions. May you say that if the Act is using its own sound system, you have no control over the volume of it? I find that a very strange comment for somebody that's managing the venue. Could you clarify that point?
Of course, Councillor Lamond, no worries. As a venue, sometimes we hire the venue as like any other venue, like this room here. We hire the venue and independent productions come in and do their own production. So in a lot of these cases, they bring in their own sound equipment and their own devices, and they control that. What I've stated in my conditions and under my new noise management policy is that we will completely remove the ability for them to do that in all circumstances. So we will have a sound desk which is controlled by management. So moving forward, that is impossible for them to do. But it's very standard practice with any venue that's hired to offer external sound control.
Well, I would have thought as managing the site, you would have had some control over that. I also need to know what decibel level you actually have in the venue itself.
I suggested to the environmental health officers that we implement a decibel reader in the venue or a sound limiter, which basically limits the sound maximum that's allowed to be exported. But the environmental health officer, and I think they'll probably agree with me, said that that's probably irrelevant because it's the building that we're arguing that's not suitable. So it's about how the sound escapes, not the sound that's internal.
Yeah, but the whole point is that if you've got a large volume in there, then you can ascertain the actual soundproofing of the venue itself, because you have to consider.
Of course, but let me clarify that, is that even the applicant today hasn't ever suggested that the sound was too loud. What they're suggesting is that the escape of the sound is not relevant because of the building. I believe, yeah, that's correct. So there's never been an argument or debate of whether we've played too loud. They've even said that we've been responsible and reasonable and we've managed it effectively. They've never suggested once that we've gone above a reasonable level. It's the fact that the sound was escaping that was the problem, and we're obviously going to look after that if that is the problem. But that's why we tried to cooperate, and we were looking at different methods moving forward, and we weren't given that opportunity to continue cooperating with the authorities to try and do that. And that's essentially, I mean, what I would love today is for us to have a fresh, I don't think this report is good enough. I don't feel the statutory guidance has been followed. I don't think it's good enough, and they've broken statutory guidance by not continuing to cooperate with me. So what I would like today is the committee to essentially give us a chance to continue that cooperation. I don't want to cut off ties with the environmental health officers today. What I would like is to work through this noise management policy, meet up with them next week, and see ways that we can work towards this, because effectively we only need to reduce the decibels escaping by like 5 or 10, and it would be defined as I mean, I already think it's reasonable, but for the avoidance of doubt, if it's not reasonable, then I truly believe that it's incredibly easy to reduce the decibels by 5 and 10. And I'd really welcome, I mean, Abigail's an expert in this. I'd welcome them down to help me do it. I'd be more than willing to cooperate with them, and I would invest in that to make that happen. You know, I would do that. I'd happily do that.
I have a question with regard to the noise management and sound reduction plan that you put forward. The first question I have is the reduction of 3 speakers, I think you've put here.
Yeah.
Currently got 5.
Mm-hmm.
Are the 2 speakers that are on the proposed floor plan setup, are they on the stage? Are they still in place or are they
Yeah,
out?
so what the idea is that, say, everybody admits today that the noise we're producing isn't the problem, it's the escape of the noise. So what we're trying to do is basically stop that happening. So we're trying to move the stage back away from the front doors, because that's where a lot of the noise is escaping from the windows. And we have got currently 5 speakers, of which 3 are directed towards the doors and the windows. We're going to remove those 3 completely get rid of them. In fact, they've already gone, so that's already been done anyway. And we're going to put 2 speakers on the stage. We're also, because the applicant obviously noted about the bass bins travelling through. We've removed the bass bins. They don't exist anymore. They're completely gone. So that will completely resolve that issue of the bass going through the windows.
Sorry, I still count 5 speakers then.
Yeah, so no, sorry. So on the report, there's little colours of images. So the 2 that's remaining is the 2 ones that are on the. So you've got 2 images there. One what is current, and the image on the overleaf is the one that we're proposing. And in that image, it shows 2 red ones just by the stage. I've left the other 3 on there for reference of the ones we're going to remove.
So the two that are on the stage are remaining.
Yeah.
But the 3 in bright red are
going because they're pointed towards the doors and the window where the noise is. They're going. Well, they're gone. They're already gone.
What direction are the speakers on the stage going?
They're going to be pointing inwards with a curtain on either side. The idea of the curtain is it absorbs the overflow sound that escapes from the side of the speakers. So they're on the stage facing in towards, not out towards. And there'll be soundproofing panels at the back of the room to absorb the sound.
Okay, so now on to soundproofing. One of the major problems is the glass.
Mm-hmm.
It reverberates and re-echoes the sound within inside and comes through.
Correct.
Do you have any air conditioning in your premises?
We don't have air conditioning in the premises at current, no.
So how do you ventilate the room at night?
The room at night? Oh, okay, sorry. So we have external ventilation via the extractor fans, which runs on a continuous fan element at the back of the room. So we use the ventilation via that method.
So what about because when I was there on Saturday,
You were here Saturday?
Yes, I was.
Oh, okay.
When the windows are open, because you've got the fixed glass panels all the way around.
Yeah.
Then above them, you've got the windows.
That's right.
Are those windows open in the evening?
Never. And that's why we don't do events in the summer. That's why there's only 1 event in July, and there's no events in August and no events in September, because it's not an appropriate venue during those months, because you would have to open the windows. That's on purposely why we don't put music, because we're trying to be responsible. We don't put music events on during hot months.
They were open at lunchtime, yes.
But there was no sound. That's what I mean. We wouldn't be doing live music whilst it's summer. That's why we don't have any events currently.
Okay. My last question is, actually, no, I've got 2. In one of the representations from here, bear with me a moment.
No worries.
There's a lot of paperwork here today. From 6 West, from West Mews, no, there's a representation.
So before we, is the one representation that is to be considered? The one.
Single one. From the resident whose initials SK. They raised the problem of people leaving the premises in the evening, close of play. The staff do nothing to limit the noise of people in the premises, people loudly shouting and singing, etc., etc. Well, can I ask a question? What particular current arrangements do you have in place to ensure that your clientele leave the premises quietly and that they respect the privacy of their surrounding residents?
First of all, Chair, let me just clarify that the complaint in there, the representation, has issues which are unrelated to this application today. And it's one of the reasons that they brought forward their representation We have never had a complaint of noise outside the premises. We do not put outside seating there, for example. We're allowed to, but we don't, because we don't want to encourage loud noise outside the venue. We also do two things. On events where there's a large capacity or a large ticket sale, we employ 2 doormen, which stay at the door, and their job is to open and close the door respectively. What we do on the departure of all events, so the second an artist is off stage, our manager, which is to my right here, stands on the door and basically ushers people in and out of the door and allows them to leave. We also have a taxi booking policy that we do. We have a deal with a local taxi company, and we can book taxis in advance of people. So to be honest with you, that's something that we cover really, really well. And to our knowledge, although we've had a few people come to us about noise before, we've never had in the 3 years we've been there anybody complain about people leaving. That's just not something, as far as I'm aware, that we've ever heard at all. People leaving has just never been an issue, to be honest, because we do control that really well.
Do you have signage, and do you make announcements on your PA system at that time?
So we don't have any signage on the door to say, please, leave quietly, respected neighbours, but I'd be more than happy to add that as a condition, because I know that's a condition that I'll be happy to add on to there, and we would do that. However, as I say, it is encouraged from a management perspective. This man to my right is incredibly strict and scary. So a lot of the time he stands by the door and tells people to keep it quiet and things like that. But I'm happy to add a condition that we put a sign on the door to encourage people to leave quietly.
Councillor Westwood.
Thank you. I do have a question for you. So, is this working?
Yeah,
it is. Okay. Earlier on in the proceedings, you said that this is a local venue, only local people, no passing, but you just made reference to a taxi policy and taxis now, so which suggests that it's not, when you hold these events, a local event.
Correct.
Because you are having taxis there. So, 2 questions. One is, what size are the events? What's your average attendance?
Mm-hmm.
And what would you say is the proportion of local attendance to those needing taxis and other ways of getting around?
Okay, so in relation to the event size, obviously the license allows us 500. That's just ridiculous. The fire regulations allow us 178. I can sit here now and honestly tell you we've never had an event above 75, purely because the kitchen can't handle more than 75. So we always limit the events to a maximum of 75. However, if you look in the reports, it shows, and they've obviously done a report where it shows a massive fluctuation with attendances, and this ranges from 15 to some events up to the maximum of 75, which is usually like the Michael Jackson night, for example. That's incredibly popular and usually generates 70, 75 people. But I would say a mean average, probably 40 to 50 as a mean average. In relation to the local usage, it solely is, I mean, you've got to remember, say, because it is the only hub, as we said before, it's the only place that people can come to. It's the only kind of watering hole where residents can safely walk home afterwards. It is massively used by the local community. For example, the chairman of the local association, Lorraine Rapé, she's a regular user. Councillor Craig Manuel is a regular user. We have all local residents use the property. The reason I say about external is obviously, and your point's valid. Obviously, I stated that we have no passing traffic, and that's the most imperative thing, because as a hub, or as the hub of the village, we've only got a certain demographic that will pass through and have a pint. You know, like a lot of, like, for example, Wickham, beautiful square. People go to Wickham for the day, look around the shops, and pop in their local for a pint. We don't have that ability, so we need to look at raising finance elsewhere. I mean, as the applicant said, there's been a lot of failed businesses there, a lot, which have only lasted a year or two, and we're currently in our 3rd year. And the reason why they failed is because they don't, get people in from outside the village. It's not a sustainable business for just internal sales. So the events really for us are a way of securing the finance to fund the restaurant being open the other 28 days of the month. And we do get external people come in. We get a lot of people from Wickham, a lot of people from Southwark and surrounding areas, because we're the only place in the ward that offers kind of a live music thing. So we do get people come over from them, especially Wickham. But I would say, if you're looking at an average, I would say 70 to 80% of people on live music events are local residents. So it's heavily used by them. As I say, from my knowledge, And we can only go by what the report says today. There's only been 6 complaints, and we don't know if these are individual people. We don't know if they're the same person complaining 6 times. We don't know because the report doesn't state that. However, what I can say is since we've started doing live music, which by the way started in July 2021, and we didn't get our first complaint until December, so that should alone back up the licensing objectives, that we've had just over 1,000 people come through our door.
Mr. Madrig, I think you've answered the question.
Thoroughly.
Yes, go ahead.
Thank you. You talked about a taxi policy. We talked about mitigation issues for sound leaking from the building. Do you have a policy for engagement with local residents around you so that you can understand their needs and the impact of your business on those locals so you can mitigate that impact?
Yeah, and I think that's a really important question. And the reason that's important is because this entire thing, the reason we're here today, it all triggered from that first temporary event notice in December. So to give you an idea, our manager, who was before Chris, Ben, he went round and put letters through everybody's door to make them aware that we had a late night 10 license. There's a Knoll residents Facebook page, which has got pretty much every resident in the village on there. And when you put a post on there, it confirms the people that have read the post. And also we went door knocking as well. So there's a few things we do to engage. What we also say is we also say to people to come in. So for example, to give it, I mean, obviously you've seen item 6, I think, in the report, where people said, you know, that I was responsive in this respect. They messaged on Facebook and said, can you turn it down? And we turned it down. And they said, thank you, you've turned it down. So we are responsive. But also, to give you an example, we had a gentleman come in December and spoke to me personally, and said it's too loud. And when the artist had their break, we asked them to turn it down because he was unhappy with it. So I must say that he said he said that if it was a punk rock band, he wouldn't mind so much, but he didn't like Adele too much. So, you know, it's personal preference. But no, we do encourage people to come and speak to us. And our new noise management policy, which we'll implement, actually states that we will from now on provide all these details to the customers, which I'm happy to do from this week. Send all the letter to local residents. If they've got any problems, they can speak to me directly. That's absolutely fine.
Thank you, Mr. Madrid. Can you? I've got a last question. Can you say whether or not you agree with Mr. Tittridge's statement that it was suggested that live and recorded events were restricted to 1 per calendar month, finishing at 10 o'clock, and that an additional event of 1 a.m. finish would be allowed for New Year's Eve, and that he was under the impression that you agreed to such a restriction, but that you wanted more on Christmas?
To confirm, that was in May, when they, as I say, I thought that we were still cooperating and going to look at other options, and they sprung that on me. And I didn't say that I'd agreed to it. I said we could look at it as an option. I said, but December is really a sticking point for us because we take more money in December than what we do in January, February, March, and April combined. And like almost every hospitality industry, we completely and utterly rely on December. You know, as I say, some months, next month, this month, we don't have any live music. So, you know, 1 a month is irrelevant to that. But we need to try and maximize our income and revenue when we can. You know, as I say, the business is not viable via proof of all the other people before us closing. It is not a viable business just for local residents. We have to look at external methods of revenue. That's just business. We have to. And as I say, of course, we don't want to be a nuke. Do you think we want to be here today and do that? We don't want to do that. So we will do everything in our power to ensure that we're not a public nuisance. Of course we will. Of course we will. It's, you know.
Okay, thank you, Mr. Medri. Right, I think the committee will now retire to consider our decision in this case, and so the meeting is now adjourned.
I'll just make a quick summary.
No, you may not have
okay,
adjourned
no
the
worries.
meeting. Welcome back. This meeting is now ready. In reaching its decision, the subcommittee has carefully considered the review application, the applicant's evidence, and supplementary documents. We did not consider any late representations received from either the applicant licensing authority or the respondent license holder. The subcommittee has taken into account the Council's statement of licensing policy, public sector equality duty, the Home Office guidance issued under Section 182 of the Licensing Act 2003, the duties under the Crime and Disorder Act 1998, and the rights set out in the Human Rights Act of 1998. Factual findings. Supporting evidence of the applicant for review, Philip Tittridge, Environmental Protection for Winchester City Council, shows the Wicks Bar and Grill is a listed building and possesses poor acoustic insulation. The venue is in close proximity to residential premises, in some instances only a few meters away. The monitoring of volume of music from within the nearby residential premises reveals the events over the 10th to the 16th of December 2021 and the 18th of March to the 23rd of April 2022 to have been intrusive and above the recommended levels for rest within a living room or bedroom, as witnessed by a qualified environmental health officer. It has been agreed that there were no issues with the calibration of the equipment used to monitor sound levels from various complainants' residential premises. Evidence provided by the license holder shows they have a proposal for a soundproof contractor, which may result in reduced noise levels experienced by residents outside the venue, but this has not yet been employed. They have responded to a complaint when received direct. Though they possess equipment necessary to control the volume within the premises, acts on occasion choose to use their own equipment, which cannot be controlled by the license holder. There is a proposed floor plan layout changing number, location, and direction of speakers, which may reduce further noise levels experienced by residents outside the venue. Based on these findings, and having considered them on balance, we are of the view that the licensing objective of preventing public nuisance was not promoted. And as a consequence of our findings, we find it reasonable and proportionate in all the circumstances to make the statement under Section 117A, subsection 3 of the Licensing Act 2003, that following a review of license and findings that the prevention of public nuisance licensing objective was not promoted, that deregulation no longer applies. And that conditions will now apply to the license as follows. PN 3, limiting the number of live music events to 1 event per calendar month, finishing by 9:30, with the exception of December, which will have New Year's Eve finishing by 0:30 hours a day, and 2 further events finishing by 9:30, which shall not run consecutively on any 2 nights. No single live music event shall run for more than 2 hours in duration. Bottle bins not to be emptied between the hours of 8 p.m. and 9 a.m. Signage at the door asking patrons to leave the premises quietly, respecting local residents. The premises license holder shall ensure that a noise management plan is agreed with the Council's environmental health team prior to the next live or recorded music event after the 25th of July 2022, which shall include the proposed floor plan set up, page 11, to the Appendix 6, Supplementary Agenda 4, unless agreed otherwise by the Environmental Health Officer. The premises license holder shall ensure that a community engagement plan is agreed with the Council's Environmental Health team prior to the next live or recorded music event after the 25th of July 2022. This plan shall outline the premises license holder's proposals for engaging with the local community and ensuring that any complaints received from the community are responded to accordingly. Parties will be formally notified of the decision in writing shortly. This notification will include details of the right to appeal against this decision to a magistrate's court, which must be made within 21 days of the notification. This meeting is adjourned.